welcome to the Q&A podcast produced by C-SPAN. I'm your host, Peter Slen. Our guest this week is a federal judge, Judge Frederic Block, who's written a book about second chances. That podcast begins in a moment.
Hey there, Ryan Reynolds here. It's a new year, and you know what that means. No, not the diet. Resolutions. A way for us all to try and do a little bit better than we did last year. And my resolution, unlike big wireless, is to not be a raging and raise the price of wireless on you every chance I get. Give it a try at mintmobile.com/switch.
$45 upfront payment required, equivalent to $15 per month. New customers on first 3-month plan only. Taxes and fees extra. Speed slower above 40 gigabytes on unlimited. See mintmobile.com for details.
This episode is brought to you by LifeLock. The new year brings new health goals and wealth goals. Protecting your identity is an important step. LifeLock monitors millions of data points per second. If your identity is stolen, LifeLock's restoration specialist will fix it, guaranteed or your money back. Resolve to make identity health and wealth part of your New Year's goals with LifeLock. Save up to 40% your first year. Visit LifeLock.com/podcast. Terms apply.
Judge Frederic Block is a federal judge of the Eastern District of New York. He was appointed by Bill Clinton in 1993. His courthouse is known as the Mafia Court as it sits in Brooklyn and hears many mafia-related cases. Judge Block has authored a book entitled A Second Chance. It deals with whether some prisoners can petition for early release. Judge Block profiles 6 cases he's heard, including mafia charges, child pornography, and rogue policeman, and how he ruled. Our conversation with Judge Block begins now. Judge Frederic Block of the Eastern District of New York is the author of this book, A Second Chance. A federal judge decides who deserves it. Judge Justin Volpe, Sherwin Burkett, Joe Smith, Anthony Russo, Vittorio Little Vic Amuso, and Anthony Gaspipe Casso. What do these 6 men have in common?
Well, the first thing is that they all are in my book, but they really are examples of those who now had the opportunity to make an application to district court judges throughout the United States because Congress in 2018 enacted an incredible piece of bipartisan legislation called the First Step Act. And in that law, it gave all those folks, plus everybody who's incarcerated, the opportunity to make an application to district court judges, such as myself, to reduce their jail time. These were incarcerated people, or even to let them out of jail. So it has changed the sentencing landscape in the United States of America. And because of that, I had received many of these applications from people who had been incarcerated for many years, and I had to make a decision under this new law whether or not I should reduce their jail time or even let them out of jail. They were all long-term prisoners, some there for 20 years, 30 years, and they each made a petition to Judge Block to let them out of jail or to reduce their jail time. So I selected 6 of them for the book because I thought they each would be representative of the dramatic aspects of this new statute and how a judge goes about to decide who shall stay in jail, who should no longer be in jail. So, Peter, as a generalization, I can begin our conversation by hopefully explaining that all of this really comes from this incredible power that was granted by Congress in this major bipartisan piece of legislation back in 2018, and we're being inundated throughout the country with applications directly from inmates to reduce their sentence, and it's called compassionate release motions, and I get them every week. So I thought that this would be a good way for me to really speak out in the book that I have written by using these 6 examples of many that I have as a very good way of really talking about the dynamics of the new law and the dynamics of how judges now can take a second look at sentences that were previously imposed many times years ago, and really recalibrate the sentence and let people out of jail. So that basically, as a generalization, is really how all this came to pass and how I got the idea for the book.
Judge Block, did all 6 of these men appear before you when they were being criminally convicted?
No, because they have been in jail for a long time, and they were sentenced by other judges, predecessors of mine, some of whom are not alive. But in respect to a couple of them, they were sentenced by me. And in particular, good old Gaspar Queso was sentenced by me many, many years ago. And he made a petition to let him die at home because he was now basically terminally ill. And I had to decide whether to let him die in jail, I'd sentence him for life, or whether to let him go home and die at home. He may have forgotten that, when I sentenced him years ago, there was a death threat that he imposed upon my life. The marshals, the FBI had to investigate it, and it never came to fruition, obviously, otherwise I wouldn't be talking to you today. But he may have forgotten all about that. But in any event, that was one where I did sentence Gaspar to life.
Well, let's walk through the crimes of the 6 that we're talking about that come from the book, beginning with Justin Volpe.
All right, so Justin Volpe was sentenced by my predecessor, the late Judge Nicholson, one of our great, great judges. And I guess it goes back to, 1999 or thereabout. And that was a really, really, really high-profile situation because it basically spawned the movement of Black Lives Matter. Back in 1999, Volpe, a police officer with the 70th precinct, if I remember correctly, in Brooklyn, accosted a gentleman named Abner Louima, and he ultimately, believe it or not, was charged with assaulting Abner Louima because he shoved the broomstick up Abner Louima's rectum, and that case was one of national significance. And it spawned really the Black Lives Matter movement way back when. It was the first time that a police officer was ever indicted, convicted, and sentenced to a long period of jail for police brutality. So that was chapter number 1, because Volpe now asked me to let him out of jail. And he had been in jail for 21 months. He had another 4 or 5 years to go under Judge Nicholson's sentence. So that's a classic example of what this new law is all about, allowing people like Volpe to petition Judge Block, district court judges, to let them out of jail.
And the second case was Sherwin Burkett, convicted under the Racketeering and Corrupt Organizations Act, RICO, in 1990. What was his case about?
So that's a different type of case. So Burkett was a young man, 18 or 19. He was part of a gang of people who were just making a lot of money off of drugs, and they had a large network. And he was just a young kid working for this organization. But nonetheless, he was charged with being complicit in the murder of somebody. So he was sentenced to jail for life also. And that was chapter 2. And that represented, unlike the Volpe case, just somebody who was a young fellow who was caught up in this big gang that was really victimizing people, and it was all drug related. And so that was basically the basis of the second chapter, and why I chose him, I thought would be representative of RICO indictments.
Joe Smith, child porn, and you use an acronym for this gentleman.
Yeah. And hope I'm allowed to take some water once in a while. At my age, I'm going to do that periodically if you don't mind. But anyway, Joe Smith, I use the acronym, obviously, because I think that, you have to really respect people's privacy. And his case was not unlike the other cases publicized. But this was a child pornography case. So child pornography is such an interesting subject because they have mandatory minimums that invariably apply to child pornography cases, 5 years, 10 years, 15 years. And he was sort of charged with a 5-year mandatory minimum. And I sentenced him. to the 5-year mandatory minimum, and then he made an application for me to reduce his sentence. So that was a good example of a different type of criminal behavior, which comes under the umbrella of all of these people who are incarcerated and why they petitioned for release. So the next one, I think, are the mafiosi cases, if I remember right.
That is correct. Anthony Russo, who was also convicted under RICO. By the way, what exactly is RICO?
So Congress years ago passed the Racketeer Corruption Act and called RICO. And it was designed to really, deal with the mafia. So the whole idea of RICO, it allowed anybody who was part of an organization to be prosecuted for all of the misdeeds of the organization. So the leader of, for example, the Colombo family or the Gambino family, the Lucchese family, they were then the subject of lots of prosecutions, even though they may not have personally murdered somebody, even though they may not have been personally involved in any of the nefarious deeds of the organizations. They were held under RICO to be equally responsible because they were the leader, and therefore, as a result of that, they're responsible for all the misdeeds of the people who were part of that enterprise, so to speak. So that's what RICO is all about. And it really was the statute that basically has destroyed the effective operation of the mafia. It was designed to do that. The major case, of course, is the John Gotti case, for example. But Russo was the captain of, was it the Lucchese family, if I remember, or maybe it was the Colombo, the Gambino family. I get those names mixed up sometimes. He was sentenced to life because of the fact that he was held responsible for all of the misdeeds of the members of his criminal enterprise. So that really was the first big mafiosi case that I got in terms of trying to let somebody out of jail. You may or may not remember, or the public may or may not remember, but in 1990, they had these internecine wars amongst the 5 families. And we had a period of time where people were being gunned down on the streets. Paul Castellano was one of them, for example. He was the head of the Gambino family. And then, of course, Gotti took his place. And Russo was part of that. And this was the war, the Colombo Wars, the Gambino Wars that were going on in the 1990s. He was put in jail for the rest of his life because he was part and parcel of that.
And Vittorio Amuso, who was part of the Lucchese family.
Same thing. So he was the leader of, I forget which one. Was he the Lucchese? I just don't remember. I got the 5 families. I get them mixed up periodically. But he was also like Russo. He was the head of one of the families. Russo, I think, was the captain, the capo of one of the families. So Russo and Amuso were both big-time mafioso people responsible in jail because of the fact that they were the leaders, basically, of all these horrible things that were happening during the mafiosa world. We still love the mafiosa, but it's really much diminished than it was in those days. And I think RICO really had a lot to do with cutting the legs out from underneath the effectiveness of the mafia, even though they're still in business. But they're not killing people these days, small-time stuff. But that was that. And then the last chapter of the book, of course, is my favorite, Anthony Gaspipe Queso. And Queso was part of a cooperation agreement that the government entered into with a bunch of people. And the most famous one was Sammy the Bull Gravano. Sammy the Bull really was the one that broke the oath of Omerta because he was the one that turned against John Gotti. And it was responsible for having Gotti get convicted and testifying against Gotti. And Queso was, the backup, you might say. The government also gave him a cooperation deal, so he would be available to testify against Gotti if it was needed. But it turned out that, the government never needed Queso because, Sammy the Bull did the job. And not only that, so they cut him free from the cooperation agreement, and he didn't like that. And the government claimed that he really wasn't cooperating properly, and he breached the agreement, and therefore, the government wasn't bound, as the war with Gravano to ask the court for leniency. That's the whole purpose of a cooperation agreement. The judge then has the discretion to sentence somebody much more leniently because of their cooperation. So Casso was cut loose by the government. He complained about that. The case went through the court system, went to the appellate court, and I sentenced him to life because, as part of his cooperation agreement, he had to confess to all the crimes that he committed, and he appeared before me and actually admitted to killing 18 people. Or being responsible for killing 18 people, and that means that he had to go to jail for sure for life. And if the cooperation agreement was not going to be applicable, and I held that the government was not bound by it anymore, so I sentenced him to life. And he didn't take kindly to that, so he threatened to kill me after that. That was the first death threat I ever got.
Well, your court, the U.S. District Court of the Eastern District of New York, is known as the Mafia Court. Why is that?
Well, because, we have jurisdiction over most of these cases. Most of these folks were sort of born and raised in Howard Beach, which is in Queens. It's part of the Eastern District of New York's jurisdiction. A lot of them live in Staten Island, which is part of the Eastern District of New York. And the murders and the criminal activities came about in Brooklyn mostly, in the Eastern District of New York. And I think the bodies were buried here. So we have jurisdiction over most of the mafia cases because of the connection that they have through their misdeeds, through their residencies, through their living patterns in the Eastern District of New York, which consists of Brooklyn, Staten Island, Queens, and the two Long Island counties, Suffolk and Nassau County. So the country is divided into 94 districts, and they're not all correlated roughly to population, but roughly it's basically a population-oriented dynamic. In New York, we have 4 of the 96 district courts. We have the Eastern District, which I just mentioned. The Southern District is Manhattan, Westchester, some of those upstate counties near Westchester. Between the Eastern and the Southern districts, those are really, that covers the megalopolis. That's where really most of the action happens, between Brooklyn, Manhattan, thereabouts. The other 2 districts are located upstate. The Northern District, covers Albany, Utica, up to Canada. The Western District is Buffalo, Rochester. So that basically is how the state of New York is divided in terms of the federal districts. I think I may have said 96 federal districts. I think they're 94. So we have 4 of them. So the EDNY and the SDNY, we affectionately call them EDNY, SDNY, Southern District, Eastern District. Basically, I guess really in the United States are the primary courts which handled a lot of high-profile cases because it's New York. And that basically is a rough education about how the federal courts go about doing their business.
So, Judge Block, when you're watching a relatively modern series like The Sopranos, are you seeing reality?
Well, actually, I had a major mafiosi case. I had the Peter Gotti prosecution. After his brother John died in prison, somebody had to take over the family, and this is the Gambino family. And Peter, sort of a benign fellow. I mean, he really wasn't really caught up in that world like his brother was and some of the other Gottis. But he was the uncle, and they made him the head of the family, to keep it in the family, I guess. So the government then prosecuted Peter in a wide sweeping indictment several years ago, together with 15 other people, to try to clean up the waterfront and to really get to the underbelly of the Gambino operations. So Peter was the primary defendant in that case, together with many others. During the trial, and I write about that in the book actually also, something I'll never forget. It was really high drama. It was really made for Hollywood, and it was like Hollywood. The Soprano people would come to court, And they would, check out what was going on. And I think they used a lot of the material from the Peter Gotti trial, in their TV stuff. I think Victoria Gotti, came to court frequently. She wrote a book, if I remember, about all of this, which pretty much was a bestseller. So, and then we had Steven Seagal was one of the people who was part of that prosecution, the famous Steven Seagal, the Kung Fu master, and he was part of the extortion. And there was one count against Gotti and the gang, claiming that they extorted Peter Seagal, and that was count 64. I remember that, the extortion count, that he testified in court. Well, when he testified in court, it was like really being in Hollywood. I mean, they all came for to hear him testify in court. So it was a kind of a dramatic trial, and it's an example of the extension of the John Gotti trial. And basically, the convictions in that case really served pretty much of a death knell to the mafiosa, as it was known in those days. So I can go on and on and on, but I guess you get a sense of things.
And our conversation on Q&A continues in a moment.
This episode is brought to you by MeUndies. While MeUndies can't totally help your love life this Valentine's Day, they can offer you insanely comfy undies and loungewear to buy or gift. MeUndies has so many awesome Valentine's Day prints and styles. Plus, you can match with your partner, friends, or even your pets. This Valentine's Day, give the gift that'll keep them thinking of you and score huge site-wide savings at MeUndies.com/Spotify. That's MeUndies.com/Spotify. MeUndies. Comfort from the outside in.
So what were you doing prior to 1994 when you were nominated by Bill Clinton to be a district judge?
I was practicing law in Suffolk County. So the EDNY includes Suffolk County, but the primary geographical aspect of the EDNY is Brooklyn, obviously. But nonetheless, Suffolk and Nassau, are dealing with multi-millions of people, and they're part of the EDNY. So I was practicing law way out east in Suffolk County. I can go into it all, but, I ultimately was tapped by Senator Moynihan. He was the one, the senators recommend the judges to the president. So it really comes from a senatorial recommendation with few exceptions. So Moynihan in those days was highly regarded United States senator. He really truly had a reputation of crossing the line. He was a Democrat in name, but, in reality, he was just one of the great statesmen of our times, and he worked with Republicans, Democrats, conservatives, you name it, highly regarded. And he was the one that recommended me to the president. At that time, it was Clinton. So basically, I owe the judgeship to Senator Daniel Patrick Moynihan. But I was basically a solo practitioner in Suffolk County. I had, I think, a young junior associate at the time. So I didn't fit the conventional mold of federal court judges. They usually are members of big firms. They usually are high-profile prosecutors. Most of the judges at the time that I was tapped had been assistant U.S. attorneys in the EDNY, or some of them were the actual U.S. attorneys. If I remember correctly, when I came on board, there were 12 district court judges for the EDNY, and out of those 12, 10 came from the office. It used to be, a colloquial expression, from the office meaning the U.S. Attorney's Office. So I was really a kind of a fish out of water because I did come from the office. And not only that, but I was not a big-time lawyer, and I just had a small practice in Suffolk County.
And in your career, you've only heard federal cases, given that you're a federal judge, but what identifies a federal case?
So, it's a great question, Peter, because I'm motivated now in the process of writing another book at my tender age. I hope I'll be able to finish it. And it's really tentatively called, Can They Fix Tickets? It really is designed to deal with the fact that we have such an uneducated public when it comes to really understanding the federal judiciary, what federal judges do. What's the difference between a state case and a federal case? What's the difference between a federal judge and a state judge? So I'm putting pen to paper and I'm writing all these questions down and I'm giving the answers. And I hope the book is going to be distributed, I hope it gets published, to all of the students, certainly the high school students, because we are sorely in need of better civic education. So when you ask a question, that's right on the button, and that's the reason why I feel it's so important to try to educate the public about things which they ought to know about as citizens. And I think that, we don't do a good enough job doing that because most of the judges, basically are a little bit apprehensive about speaking out. But there are two schools of thought about that. And one school of thought is that judges have almost a moral responsibility to share their knowledge, which they've acquired over the years, with the public instead of just keeping it private to themselves. And I subscribe to that. And that's why I've written books. And that's why I'm talking to you today, because I think that it speaks well for the federal judiciary if the judges really take their robes off and try to really interact and meet the public and relate to the public one-on-one, which I think we're doing today.
Well, Judge Block, in the short term, can you identify what a federal case is for us for the purposes of this program?
Okay, so I'm losing my track, I guess, right? Basically, the federal cases are those which we call are interstate in nature. In other words, they cover more than one state. They cover the country. So if you have Congress enacting a criminal law, that would be a federal case because Congress has enacted that law and it applies throughout the country. A good example of that would be terrorist cases. Obviously, we have statutes now governing sentencing for terrorist-related crimes. Those are interstate crimes. They cover the country, so they're federal crimes. The state crimes, for example, are those that are confined to what's happened within the state. Now, the public is often confused about it because you get a murder case, and sometimes they see a murder case being prosecuted in the federal courts. Sometimes they see a murder case being prosecuted in the state court. You have Mangione, this most recent horrific situation where he shot and killed that CEO executive. He is being prosecuted now in the state courts of the state of New York, not the federal court, because he is being treated as having committed a state crime in New York State, albeit a murder. It was done in New York State. There's no federal hook to it, so to speak. Contrary-wise, you have the murder cases involving the mafioso. There's a federal hook because they are considered to be of a national character, and therefore there's federal jurisdiction. Now, this is the subject of, a law school course. I could go on for weeks and weeks about it, but that's a thumbnail idea. There are a lot of nuances about it. But bottom line, if it's within the state, even if it's murder, it's a state prosecution. If it has a federal hook to it and it goes beyond the state, then it's a federal prosecution.
Judge Block, over the years, how have cases been assigned to you? Do you have a specialty or is it random?
So it's random, basically. If you come to my courthouse and you start a lawsuit, you'll go to the clerk's office. You can do it online now with the technology we have. It used to be you had to physically come to the district court clerk's office. But you file your case, you file the summons, you start your lawsuit, and then it's going to be randomly assigned to one of the judges of the courts. Now, in Brooklyn, I think right now we have 23. So I'm one of 23. So I can be assigned that case, or any of the other 22 can be assigned a case. It's really a random process. There are some exceptions to that, but generally it's a random process.
And as a federal judge, Judge Frederic Block had to be approved by the Senate. In your book, A Second Chance, you note this fact, that out of currently 1.9 million people incarcerated in the United States, 200,000 or 10% are federal prisoners. And those are the ones that we're dealing with in our discussion today, correct?
That's correct, because the First Step Act is a federal statute that Congress enacted. We can talk more about that, but that only applies to the federal prisoners. And they're about 10% of the total jail population. 90% come from the states. And the First Step Act doesn't really apply to the states. So I can only deal with those who are federal inmates. And I write in the book, as you probably realize, that there's a real need for us to really have this power. The judges throughout the state should have that power. So people who are incarcerated in New York State, for example, would have access to making an application to a state judge to also give them the same compassionate release consideration that we now are mandated to give on the federal level. So I feel really, really passionate about it because the public is not terribly aware of all these things. But the need to really deal with our mass incarceration problem is profound. And that really is the basic reason why Congress, to its credit, acted. And they really acted. 88, I believe, of the senators voted for it, Republican, conservative, right across the political line, the ideological line. The same thing in the House. 350, I think, congressmen voted for it. And to his credit, President Trump signed off on it at that time. So important that we really try to extend this to the states, because our mass incarceration problem is an embarrassment. Look, I remember a few statistics. I don't like to toss out too many statistics because it could be boring and it could really defeat what you're trying to accomplish. But certainly when I found out that 4% of the population we have in the United States, 4% of the world's population, and 22% of its prisoners, no other country has anything close to that. So we really put people in jail. And we really recognize that we have to do something about that because it's really an embarrassment that we really jail people so much more so than any civilized, any country in the world. And that was really the catalyst why everybody, Republican, conservative, liberal, you name it, banded together to really address our mass incarceration problem. And it raises the profound issue of, well, why do we put so many people in jail? Who are these people? What do we do about all this? So I give Congress a lot of credit for doing that. And I give, President Trump at that time, he's had a checkered past, but he did step up to the plate and he did sign the First Step Act.
Well, you did mention that in the book, that 4% of the world's population is in the U.S. 22% of its prisoners are also in the U.S. 1.9 million currently incarcerated. 50% reincarcerated after release. 79 million people in the U.S. have a criminal record, and it's about an $80 billion annual cost for incarceration. And those are facts that come from the Sentencing Project, the Harvard Political Review, and the Prison Policy Initiative. When you hear all that in one swoop, what does that tell you, Judge Block?
Well, it tells me that we were sorely in need of sentencing reform. The First Step Act is called the First Step Act, and Congress implicitly was contemplating there'd be a Second Step Act and maybe a Third Step Act. It was the beginning. It kicked off the football, and finally people recognizing, regardless of your political persuasion, regardless of the emotionality which governs much of our mentality and our reactions in life, that it was necessary for us to do something concrete. So that was the First Step Act has been considered to be, Justice Gorsuch wrote about it, that the most significant sentencing reform piece of legislation of the century. So basically, obviously, I can talk more and more about it, and I will talk more and more about it, but I'm going to try to be as focused as I can to answer your questions precisely.
Well, talking about legislation in general, how much leeway does a judge have when it comes to sentencing?
So, so sentencing, of course, is really the most profound part of a district court judge's responsibility, because we have a lot of discretion. There are outside limits to it, yes, but within the parameters of what we can do, we can render a lot of different types of sentences, and they do vary throughout the country because the demographics are different in places up north than they are in certain other places down south or in the west, and the cultures are different, so the sentences are different. But it's the district court judge that has this awesome responsibility to decide whether to deprive somebody of his or her liberty and for how long. The appellate courts don't have that responsibility, so we have to make the decision. Yes, the appellate courts can look at it, the Supreme Court, but they don't have that discretion. They just are going to be concerned about the fact that we didn't go off the rails, so to speak. But basically, it's the most profound aspect of the district court judge's job, in my opinion. We have jurisdiction over criminal cases and civil cases. We have in the federal courts jurisdiction over almost everything except maybe domestic relations. So the ability to exercise our discretion is really the centerpiece of what the responsibility is of a district court judge.
In your book, A Second Chance, you talk about the Sentencing Commission, the Bureau of Prisons, mandatory minimums, 3 strikes, parole, probation, community confinement, compassionate release. What kind of restrictions do you have when it comes to sentencing? If a jury finds somebody guilty, can you give them a day, or do you have to give them 25 years? You know what I mean by that question.
Well, I think we may need another hour of this conference to talk about it all. Look, we have guidelines. There are statutes. Basically, I think we should probably realize that there is something called the Sentencing Commission, which Congress established. And they were responsible for trying to, develop some parameters to guide district court judges in their exercise of their broad discretion. So we do have what's called guidelines. And it's broken down into basically different degrees. So each crime has a particular number. And if a person is a repeat offender, there's a different number for that person. So you look at these guidelines and you get a sense of a range of what the Sentencing Commission thinks would be an appropriate range to sentence somebody for a given crime. It could be a basic extortionate crime, which maybe the guidelines would be between 26 and 38 months, things of that nature. Of course, if it's murder, it's going to be, a lifetime guideline sentence. And there are whole variations, in terms of the nature of the crime. If it's a robbery, it's a different type of dynamic. But we do have some sentencing guidelines to give us some idea of what consistency throughout the country ought to be about. So we pay attention to those guidelines. But ultimately, we're charged with the responsibility to look at each person as an individual and to really assess the nature of the crime and to balance out the nature of the crime with the personal characteristics of the defendant. So it's a balancing act. So obviously, the nature of the crime can be murder, so you understand there it is. But what about the defendant? So, you look at his upbringing, you look at whether or not he's 15 years old or 30 years old. You look at all of the human dynamics and aspect of that person's life. And you balance it all out to decide where within that sentencing range, or even maybe below that range, would be a fair sentence in each particular case. Obviously, it's the most challenging dynamic you can possibly have as a human being to pass judgment on another human being.
So, 3 strikes, is that still the law of the land, or in any way, shape, or form?
So, each state has its own laws, right? Because the crime, committed within the state is going to be subject to the state's laws. And then you have the national laws, the federal laws. So 3 strikes was the law at the time that I sentenced Walter Johnson. We can talk about that later. And I had to apply that law. It was mandatory that if somebody committed, and this is the 3rd felony, if it was a felony, even if it was not an extreme felony, if it was just, just picking a person's pocketbook up off the street, it was a felony. If you had 3 of them, mandatory life, and you have no discretion as a judge but to impose a mandatory lifetime sentence if you have a 3-strike dynamics. The case that really went to the Supreme Court on that came from California, where the person had to be sentenced under the 3-strike law in that state to life, even though the 3rd felony was stealing somebody's golf club. And that went to the Supreme Court. The Supreme Court upheld that law as a proper law, not violative of the Constitution. Now, since then, there's been a real sea change throughout the country and throughout states like New York, which had its own 3-strike law, where we're not doing that anymore. So you will find that even if it's technically on the books, that you're not going to have 3 strikes being imposed. If somebody committed 3 very violent murders or felonies, so of course that would be a factor in sentencing him. But it's not mandatory anymore, not applied certainly in New York State anymore, that if somebody simply had 3 felony convictions, regardless of what the character or the nature of those convictions were, they had to be put in jail for life. So I had to sentence Walter Johnson 28 years ago to life, because at that time, the 3 strikes law was operable in New York. It was enforced in New York, and I had no choice but to do that. Today, we don't do that anymore. There's been a change. So one of the important things about this whole concept of giving people a second chance is to realize that with the passage of time, things don't stay static. The laws change. And there's a perfect example of that is the 3 strikes law that has changed. So a person sentenced today would not be sentenced under the 3 strikes law in New York State, and I don't think in any other state right now.
And our conversation on Q&A continues in a moment.
Judge Block, what do you think of so-called mandatory minimum sentences that are essentially legislated sentences?
So Congress has the power, really, over all of the district court judges, over all judges. They create our budget. They decide what crimes should be prosecuted. They decide what the sentences should be in many cases, right? And Congress has created what they call mandatory minimums for certain crimes. And when Congress creates a mandatory minimum, the judge has no discretion but to apply the mandatory minimum. The judge has discretion to go above the mandatory minimum, but at the very least has to apply the mandatory minimum. The areas where Congress has acted throughout the years, it could provide for mandatory minimums in every case, and basically Congress will be the judges, not only district court judges anymore. But they have carved out areas mostly in child pornography cases and in drug cases. And those have been, over the years, the basic areas where Congress has decided to impose mandatory minimums. Well, child pornography is a favorite. It's obviously an emotional situation. It's really politically charged. And Congress has created a host of mandatory minimums for child pornography case. If you're in receipt of child pornography, it could be a 10-year mandatory minimum, 15-year mandatory minimum if you're involved in creating child pornography or promoting child pornography. In those, and even possession, extreme possession could be 5 years. Even in those cases, there is no wiggle room or discretion on the part of the district court judges but to impose the mandatory minimums. So we don't like that, and not because we are in favor of child pornography, but really the discretion as to sentencing should be the repository of the responsibility of the judge. Each case is individual, but Congress has just created this blanket mandatory minimum in child pornography cases, regardless of what the circumstances are, as long as it falls into one of these defined categories. So when I sentence somebody to a 15-year mandatory minimum, even though I may think that it's excessive, and under the particular facts of that case, maybe 5 years would be more appropriate, I have no discretion, and I tell the defendant, Congress is sentencing you here. I mean, I'm just the messenger right now. I can't do anything but to apply the law. By the way, there are times when I have sentenced people to more than the mandatory minimum if the case warranted it. But basically, and I think most of my colleagues do not like the fact that Congress decides what the sentence should be, and the judge has no discretion in those cases.
When we began this conversation, Judge Block, we talked about the crimes of 6 individuals featured in your book, A Second Chance. A federal judge decides who deserves it. Now we're going to look at the second chances of the 6 men. Let's begin with Justin Volpe. What happened when he came to you with a compassionate release?
So he'd been in jail for 21 years, and he made an application to be let out of jail. And, he didn't have a lawyer represent him. He did this on his own. We call that pro se. So you're not necessarily entitled to a lawyer to make these applications. You're certainly entitled to a lawyer when you're criminally indicted. And if you don't have a lawyer, then you have to be assigned a lawyer. But not on these cases. So he did it on his own. And the government opposed him. It's really, kind of a human dimension, because the government lawyer, Liz Geddes, was a former law clerk of mine 15 years before. She really wrote really very compelling submission to me as to why he should be kept in jail, even though he had another 4 or 5 years to go. And I sort of was swayed by her arguments, and I did not grant him a release. He was subsequently released by the Bureau of Prisons a year or 2 later, and he's now, a free man again. So it was a question of 21 years, 25 years, but I was swayed by my former law clerk's wonderful submission. I don't disqualify myself if I have a former law clerk, especially one that was there 15 years before. If they've been with me a year or 2, I won't handle their cases. But, she is long gone, and she highly regarded U.S. attorney, and I had a lot of respect for her. Then I had some second thoughts about it. And I was really wondering, and I reflected upon the fact that whether I really was not as objective as I should have been or could have been. And I try to, humanize, what we're obviously all about. We make mistakes. We have second thoughts. And that's one of the reasons why the whole concept of a second chance is so important, because sometimes it's so important to reconsider what you may have done before in your life that you have second thoughts about now. So the statute we have now gives us a corrective, gives us an opportunity to do that. And I've done that in a number of cases. And we have thousands of them throughout the country where district court judges are, granted compassionate release. So that was the Volpe case. I didn't send him out of jail. The second thought, I possibly would have said maybe we should assign a lawyer here. And I really wondered today whether I would have made the same decision. So I talk about that.
Judge Block, you mentioned the role of the Bureau of Prisons. Can the Bureau of Prisons release people?
So before the First Step Act, the Bureau of Prisons had the power to also reduce somebody's sentence and even set them free. But it was rarely exercised. And they did it, basically if people, would die and it was really a medical emergency or something that really, really struck at the heartstrings. But they rarely exercised that power. They would have to do that, make an application to a district court judge. District court judge would make the final decision. And I think that the statistics over the years, they did it maybe in a dozen to 2 dozen cases a year. That's why Congress acted, so that the defendant would not have to be subject to the Bureau of Prisons decision, but also can have direct access to the judge. And it made all the difference in the world.
Okay, out of the 6 cases, what is one where you granted compassionate release due to the First Step Act?
Well, now you're letting another one out of the bag. I granted compassionate release to, I could mention Burkett, and because, of his youth and because that he went to trial and he got convicted. But the leader of the gang, cut a deal and was out of jail after 20 years. And this kid, who was really, a juvenile when he was caught up in this nefarious world, was in jail for life. I didn't think that was right. And the other thing is that I don't grant compassionate release motions willy-nilly. They have to prove to me that they have really been reformed during their incarceration, that they've engaged in significant rehabilitation. We just don't pardon people willy-nilly, let people out on the streets. So we're very, very careful in who we give this type of special relief to. They have to really show that they have really rehabilitated themselves, that they've been good prisoners, so to speak. And that's the sine qua non of what really I look at. If somebody has not been behaving themselves in jail, I'm not going to grant compassionate release. So the recidivist rate for the ones that we throughout the United States do grant compassionate release is basically nothing. Because we're so careful about, who we let out of jail. It's not a recidivist problem. The public has some concerns generally with that. They think that, maybe if you let somebody out of jail, they're going to commit another crime. It's not the case. When people are old, 55 and older, when they're sick, when they really have reformed themselves, they are not recidivists. The statistics just show that it's negligible compared to the high rate of recidivism we have when people just get out of jail after being charged with a crime and serving their time. So those are two examples. You maybe spilled the beans on 2 of my 6 cases. The rest of them, maybe the reader can find out what I did.
Yes, Judge Block, that was a compromise. We're not going to reveal the other ones. The six cases we were talking about, Justin Volpe, Sherwin Burkett, and Joe Smith, child pornography acronym, and then the 3 mafia cases, Anthony Russo, Vittorio Littlevic Amuso, and Anthony Gaspipe Casso, also a mafia murder case. Those are revealed in the book, A Second Chance. You use the term sine qua non. What does that mean?
Sine qua non? I'm not so sure what context I use it, but the sine qua non means what? Just, sort of unique to itself.
Do you feel as a judge that you get to know the defendants at all during a trial?
Well, yes. Look, at sentencing, I have a responsibility to really get to know who that person is, because no 2 human beings are alike. They have different backgrounds, and there are a whole bunch of variables. So we really educate ourselves. We get reports from the probation department. I talk to these people. I listen to the lawyers. We get letters submitted to us from all sorts of parties. And I try my best to get a good sense of who that human being is. I try not to treat like one human being is the same as another. That's not the way I do it. But I try to engage in meaningful discussions. During sentencing, I try to familiarize myself with who this person is as best as I can. I just wanted to say one caveat, since we're running out of time now, Peter. Those 6 cases I use are just representative to try to explain what this whole new discretion is all about. And they each give different dynamics to give the reader an opportunity to understand why people are being let out of jail. But it's not really the only cases. I've had many cases. In the United States, so far, 5,300 of these compassionate release motions have been granted by district court judges. And they're all very carefully crafted. And the recidivist rate is 0. And so the public need not be concerned about that. The problem is not, about the people we let out of jail. Basically, we worry more about the people we don't put in jail, I think, is a dynamic here that I reflect upon. But the public need not fear about the people who are getting out of jail because of the First Step Act. And each of those cases, I don't think we have a recidivist problem at all there. Anyway, I've gone a little bit beyond what you asked me, but, I'm trying to just make it clear to whoever is going to be listening to this that we're dealing with a basic rudimentary concept that people change, life changes, laws change. And I think that federal judges, because of the statute, are given the responsibility, I think it's a great responsibility, to take a second look at what they may have done in the past and to see whether or not, because of the changes, because of how people evolve through the years, even though they're in prison, that people deserve a second chance. And that's basically the substance of why I'm writing about all this, why I'm talking about it. Those 6 chapters are just examples of it to give the reader a feel for it. And it has a bit of a drama to it to make it a much more readable book.
How often as a judge do you have second thoughts about a sentencing?
I try not to do that because if I have a doubt, I'll sort of like give the defendant the benefit of the doubt. We call it lenity. So I can sleep well at night. And I think that if a judge has the doubt, that the judge has a responsibility to be less harsh in the sentence rather than more harsh. So I'm okay with that. Do I have second thoughts over 30 years? Well, I had second thoughts with the Volpe case in that situation. But basically, I'm okay because I really, really believe that if there's a doubt in my mind, I should resolve that doubt in favor of the defendant and not the government.
Is this possible, or has it been enacted yet at the state level, the First Step Act in any states?
So there's some movement in the states. We have a long way to go. And much of my book cries out for the need for the states to get up to speed. New York State is a perfect example. They have a piece of legislation called the Second Look Act that's been put out for enactment for the last 3 terms or 2 terms. The governor hasn't signed off on it. The leadership hasn't sent it to a vote. It has enormous bipartisan support. It ought to be done. And there's a great effort being made to hopefully this legislative session to get the Second Look Act enacted in New York. It basically tracks the federal First Step Act, but it gives people who are in jail, like the prison journalist John Lennon, who I write about, the opportunity to be released from jail, deservedly so, instead of having, the rigid application of the law. And we have to enact that law in New York State. Now, the District of Columbia has done something. There's been a little bit of movement in some of the states, not as much as it ought to be. A handful of them. I think Colorado has done something. I think Pennsylvania has done something. We have a long way to go. I write about Arizona, sorely in need of change. I write about the Stephen May case and how horrendous that is. And he's in jail for life. He definitely deserves a second chance. So the state's got to really get up to speed here. And I hope, during the rest of my life, hopefully it'll be in another few years, that I'll be able to make some impact by my book and by my speaking and by talking now on CNN and C-SPAN that we need to really get the whole country up to speed. What's interesting also is that, for example, one of the blurbs on the back of my book, I have Hakeem Jeffries, which is great. But I also have Grover Norquist. And, I want to balance it out. I don't want this to be a book that's looked upon as a liberal book or a conservative book, but hopefully a book that'll motivate people to really think a little bit about what we're all about. So he supports this because we have this enormous economic burden, $80 billion a year to support our prison system. So he just, gave me a nice blurb, and he has spoken about the fact that this is consistent with the philosophy. We just spend a lot of money. We waste a lot of money, and we should really take a hard look at whether what we're doing is the right thing to do from all perspectives.
A second chance. A federal judge decides who deserves it is Judge Frederic Block of the Eastern District of New York's 4th book. A 5th is coming, a 101 on the judicial system. Judge Block, thank you for spending an hour with us on C-SPAN.
Well, thank you for having me. I hope this was effective.
Well, thanks for listening to this week's Q&A podcast produced by C-SPAN. If you like this podcast, tell your friends, rate and review us, and follow us on social media @BookTV for more updates and schedule information. Next week, our topic is Martin Luther King Jr.'s iconic 1963 letter from Birmingham jail.